For those of you just joining us, I wanted to welcome you again to this talk called Professionals Speak. Um, this is one of several series that ISNAF puts on as a benefit to parents in this particularly difficult situation. And tonight we'll be hearing from a Canadian attorney whose name is Brian Ludmer. And it's really a chance for you to kind of listen to the information and think about how your own personal situation would apply, may or may not apply to some of the things that he's discussing. And this is one of many talks that we give. We welcome your questions. We welcome your comments. I'm just going to go through a few more announcements that we have. Services and different types of materials we offer to help parents going through this extremely difficult situation. This handbook by ISNAF, if you can see, I may have an old copy right here. It is curated content, legal content, as well as health information to help parents understand what is going on in terms of the legal process, in terms of the process going on with your child or children, as the case may be. And while this book was created in California, I can say that a lot of the information, it's compiled from some of the best writers, psychologists, lawyers, researchers in this area of parental alienation. And what the book does give you, and I can attest to it because I have used it and I find many of the things to work, is that they take all of the information that's been done in however many decades and they distill it very successfully into different types of, you can see, bullet point checklists and other things that can help you take all of the details of your horrible experience and put them into a context so that when you go speak to lawyers or you speak to therapists or whomever, teachers, even your family members, you'll have a better way of conveying your story so you can be more successful. So I encourage you to go to the ISNAF website and consider purchasing a book if you have not done so already. On that, I will turn it over to Cindy, and she will read the disclosures for this evening.
Thank you, Gina, for going through so many announcements. As of tomorrow, Monday, we will be sending an email out, and in honor of Parental Alienation Awareness Day, we are releasing our Judges Handbook. So if you would like us to send a copy of the handbook from ISNAF to your judge on your case, send us your email and you will get an email where those instructions will be sent out, and that email will be going out tomorrow. We will compile that list and then we will send those complimentary to the judges, and that will be on the money that you've all donated throughout all of these programs. We intend to send every judge that we receive a name from, and those we can get names from in each state. California alone has 100. We already have compiled that list. So do send us. You need to give us the exact mailing address, whatever department they're in, and their name, and it will be going out from ISNAF. And watch for that announcement. We're very proud of this project. We've been working on it for a while. So with that, I'm going to read our disclosures, and we have a professional on the phone, so it's just important for you to keep these in mind. And that's by participating in the support group meeting, you are acknowledging you understand there are no mental health providers or attorneys on the call, and that nothing said here is in any way to be interpreted as mental health counseling or legal advice. And while Brian Ludmer is an attorney, he is not licensed in the United States. However, he is an expert in the world of parental alienation. He does work in the United States as a strategist, and he will interface with your attorney and help you develop strategies as to what you need to do. So with that, he will be speaking about how do you get orders to get into an intensive program. So I'm going to review one page from our handbook of what is an intensive program, why do you need an intensive program. So I'm going to read from page 4, and there are 3 levels of parental alienation. So parental alienation of children can be manifested in different ways and to different degrees. It is important to understand the degree of alienation to know the proper treatment. Traditional therapy or reunification therapy is not effective in severe cases. Cases can be categorized as mild, moderate, or severe, depending on the various factors. So most parents who come to ISNAF are somewhere in the moderate to severe, which means most of you are probably in that space. So we're asking you to keep in mind what level you are at. So when you go to court, you make sure you get the right therapy. And if you don't know what therapy you need, traditionally, judges and minors councils will just put you through the ringer on reunification therapy, individual therapy, reunification therapy, evaluation, and they'll keep coming up with the same conclusion, and you'll get on that little vicious circle. And if you are dealing with severe alienation, those actually do make it worse. Dr. Stephen Miller will probably speak to that when he gets on, does our call in May. So let me just briefly go over what is mild. Mild refers to cases in which the child objects to, criticizes the targeted parent, but yet enjoys the presence of the targeted parent once time passes, or when the location is no longer in close proximity to the alienating parent. Moderate. Children will usually go to the targeted parent after expressing and demonstrating significant reluctance. Also, moderately alienated children will express consistent negative feelings toward the targeted parent, whether or not the alienating parent is present. Although these children may enjoy the time they spend with the targeted parent, they may not admit this in the presence of the alienating parent. And finally, severe alienation. Severely alienated children have little, if anything positive to say about the targeted parent, and often rewrites the history of their relationship with the targeted parent. They seem content to avoid all contact with the targeted parent. They may reject an entire branch of their extended family and often threaten to defy court-ordered parenting plans that schedules them to be under the care of the targeted parent. So Brian will be speaking to you today about what do you need to do to get those orders that you need with the 90-day stay away. I will invite you to visit our YouTube. It's under ISNAF. And we did post our presenter from January, which was Lynn Steinberg. And it's an amazing presentation. And so Brian's presentation follows so eloquently behind it. Lynn spoke about what do they do in those 4-day intensive programs, and what is necessary to accomplish the reunification. And she goes in depth with what happens inside the intensive programs of which she herself has been trained and does run those programs. So with that, I'm going to turn it back over to Gina to do our introduction.
Thank you, Cindy. I am very pleased to be able to introduce Brian Ludmer. Just for your background, Brian Ludmer is a Canadian attorney whose practice focuses on cases involving high conflict divorce, denial of access, and parental alienation. Brian works as special counsel with U.S. and Canadian and foreign attorneys and mental health professionals in the field of high conflict divorce and parental alienation. Brian has co-authored a book, which I have to show you for all of you those. It is called The High Conflict Custody Battle with Dr. Amy Baker and Dr. Michael Bone on related cases, on related issues. It can be found on Amazon, Indigo, and other online book retailers. I do personally have used this book and can attest to the fact that it has a tremendous amount of extremely helpful information so that you can help maintain a healthy relationship with your children. So he is also a business and securities law attorney with more than 32 years of experience and many years of experience with cross-border merges, IPOs, and securities transactions. Brian uses this knowledge on his high net worth family law cases. Brian is dedicated to sharing what he has learned from all of his clients and cases and from his own personal experience with professionals and targeted parents across North America. In 2014, Brian participated with many of the leading North American mental health experts in parental alienation at a colloquium sponsored by ISNAF. Brian is a frequent speaker in multiple media sources and has spoken for ISNAF, the PAAO, the Children's Rights Council, the Canadian Equal Parenting Coalition, Family Access frequently in its webinars, and gave 2 papers at its 2019 conference in Kentucky. Brian gave papers at the 2017 Parental Alienation Study Group Conference in Washington, at the 2018 EAPAP, forgive me for the acronyms, conference in Zagreb, Croatia, and has also given presentations for other organizations across Canada and the United States focused on high conflict divorce and grandparents' rights. Brian is participating in a postgraduate specialist parental alienation course conducted by practitioners in Ireland and Malta. Brian is a founding member of Lawyers for Shared Parenting and drafted much of Bill C-560, a 2014 proposal to amend Canada's Divorce Act to introduce a rebuttable presumption of equal shared parenting. Brian was an invited witness to the Canadian House of Commons in 2018 and Senate committee hearings in 2019 on Bill C-78, amendments to Canada's divorce legislation that took effect in March 2021, where he presented on equal parenting presumptions and the rationale for them. Brian is a legal editor of the Parental Alienation Study Group bi-monthly newsletter. Brian has been successful in advancing the law and understanding of the dynamic through his tireless efforts on behalf of his clients and has been counsel or co-counsel on many of the leading cases in this area across Canada. The jurisprudence on several of Brian's cases have made meaningful advances in legal remedies in Canadian court. In the legal remedies, courts are directed to use in denial of access and parental alienation cases. So, without further ado, thank you very much, Brian, for offering to speak tonight. We are very curious to hear what you have to say.
Time I spoke for ISNAF, I did a presentation on therapeutic interventions and what is necessary to structure a therapeutic intervention that has a chance of working, because the experience, and you see it in the jurisprudence, I'm going to show you some examples this evening, it is quite clear, as is the mental health literature, that in these sorts of intractable cases, standard therapeutic techniques not only fail, but they're contraindicated in the sense that they will actually do more harm than good. So that sort of structured therapeutic intervention should always be tried, because the ultimate remedy of a timeout for the favored parent, temporary timeout, and make-up time, which is how we pitch it, for the target parent and children, followed by reintroducing the favored parent. While it has a great track record of success, and I'm going to speak to that because it is one of the areas that you really need to stress, both the jurisprudence and the mental health literature, because there is a robust body of knowledge now. Nonetheless, courts, and probably justifiably, treat it as a remedy of the last resort, in the sense that they want to try other potential interventions first. That being said, there's also a lot of court decisions that get to the finish line many years into the case and sadly express that it would have been much better for this sort of intervention to have taken place much earlier in the case. And there's a long line of cases that cite each other for that proposition. So we really should be learning from all of these judicial pronouncements. We should be sharing this knowledge internationally, which is what I do. And another reason why I'm participating in this course that Brian O'Sullivan, an excellent practitioner He's a social worker in Ireland, and Charlie has a party who runs a clinic in Malta, of all places. Um, they know as much as any of the North American experts, and it's very gratifying to see that. When I have spoken in Europe, both in London in 2018 and in it was virtual Zagreb, Croatia in 2020. That was for the European Association of Parental Alienation Practitioners, and also quite gratified to see the expertise that exists in Europe, even though to some extent certain countries are behind the North American knowledge. This is a worldwide problem. People are people, and family dynamics are family dynamics. And despite local cultural differences, we see the exact same sort of pathologies and maladaptive adjustments to a high conflict family breakup happen all across the world. And so we really should be sharing knowledge. And that's why it's great that ISNAF and other organizations do these sorts of webinars and archive the presentations so that that knowledge can be shared. Even though I've been graciously given, I guess, an hour and a half, there's no way you can do justice to everything there is to know in terms of if you have one of these stuck family systems, what do you do to get the ultimate remedy imposed? That would be impossible to do in an hour and a half. So I can only hit the high spots and give you the broad-based, high-level principles, and then, of course, the secret sauce, if you will, is in the execution. So, if you had 5 minutes to describe to somebody why a particular situation requires a protective separation, and then some very specialized interventions. And again, Lynn Steinberg has spoken to that last time. And then the secret sauce there, of course, is in the aftercare after the 4-day intensive program. The first thing you'd say is, since a lot of judges waffle between, we need to strongly consider this sort of remedy early in a case, and yet on the other hand, it's a remedy of the last resort. How do we reconcile that? Because we could go all the way to proving that we have a classic case of what we understand to be parental alienation, and yet have a judge at the end of the day say they're concerned that it's too invasive in the family, or that it's too much, the children wouldn't be able to tolerate it. So you really do need to have a very strong case and have the judge really understand the principles. So I have two advantages in terms of my being able to try and give you a succinct overview of how to meet the very challenges that I've started to outline. One is I'm just coming off a 5-week classic alienation case where the debate at the end of the day between, if you will, the bid and ask for both parents is, do we try yet another unstructured, though intensive, therapeutic program, one ostensibly designed for these sorts of families, but where the children will remain resident almost entirely with the favorite parent? Or do we say, no, enough is enough. We know enough to know that that would be futile, and indeed probably further damage the children. So I was successful in that case, and I'll describe briefly the parameters of that. And I have that client's consent for me to share the particular submissions and documents in that case. Right now, they have just gotten back from one of these programs, and it's going well. There's still challenges, but they've set a whole bunch of first times, if you will, as a result of the structural change in the family. And that's one of the arguments that I'll be addressing shortly as something that makes a difference when you're trying to explain to the court why this sort of remedy. So that's one advantage, is that I've just completed this whole analysis and detailed written submissions and a day of oral submissions. So everything is quite fresh. It's the fifth or sixth time that I've been successful in getting this sort of remedy. And I have a couple more pending, one where I'm co-counsel. The other reason why it's a very convenient time for me to be speaking to you is on Friday, just a couple of days ago, a judge who I'd argued a case before last fall had reached out to me because he is speaking before a continuing education forum for other family court judges, and had saw me present the case and felt that I might have some things that I had written and other materials that would be of assistance to him. So it was quite an honor. And over the course of Friday, I was able to assemble some materials that I think will be of assistance and upload those. And it's that collection of materials, and which includes certain of the key materials from the trial that I just completed, that was all neatly organized, as it turns out. So that's what I'm going to refer to in the course of today's presentation. So before I get into some of the particular details, let's kick it back up to the 80,000 foot level and take another look at the challenge and ultimately the message that has to be sold to the court in the course of the evidence and submissions on law and submissions on the evidence at one of these adjudications. One of the difficulties, of course, is that I know that in many jurisdictions, it's highly unlikely, if not impossible, that you'll get a 5-week trial. So how do you prove one of these cases if you don't have sufficient time? That's not the topic for today, but I can tell you that a skilled legal practitioner, knowing that the other side of the case is also going to have to sharpen their pen or pencil, I guess, so to speak, and compress their case. And so everything will be submitted with just the best of the best of the best. And you should be able to. There's obviously a bottom limit somewhere there where you just have to say, I can't prove one of these cases in 4 days. Like, it's literally impossible. And that's just something that you have to take up with the judge assigned the adjudication. So assuming you have the time to do so in the case, here's the argument. Number one is we have tried the conventional remedies and they have failed miserably. And that would include a compliance motion. So presumably there is a court-ordered parenting plan that is not being complied with, and you would bring a compliance motion and you would seek associated remedies in that context. And let's assume for the sake of argument that a judge found non-compliance and gave you your additional remedies, which might be a structured therapeutic intervention, which is really not therapy, it's a psychoeducational directive intervention. And for those of you who heard my last presentation, that's what I'm talking about. As well, judicial admonitions of the offending parent, etc. And then let's assume that that structured therapeutic intervention had been tried and also was unsuccessful in restoring healthy relationships in the family system. What do you do then? Well, in a sense, there is nothing more that can be done. There are really no other types of interventions in these sorts of circumstances. The authority of the court under the scenario that I gave you is being completely ignored, and we see that quite often, how bold or how superficially compliant but not really compliant alienating parents can be. In one case I was involved in, and I'll see if I can remember it almost literally, I may be paraphrasing certain things. Great piece of judicial rhetoric. The judge wrote, although she became adept at mouthing support for the children's relationship with their father, it became apparent that such assertions were hollow and completely devoid of meaningful substance. So there's a great piece of judicial rhetoric, and in many of the cases where a change of residence has been ordered, judges have spoken to that there's huge inconsistencies in the favored parents presentation. They're always stating they're fully in support, but in parallel, they're making all kinds of accusations and assertions and throwing mud at the targeted parent, which leads you to the conclusion that they couldn't possibly be supporting the children's relationship with the targeted parent if that's how they actually feel. You really can't have it both ways, or as they taught us in the first class of first year law school, you can't suck and blow at the same time. So at that point, you should be pulling out the jurisprudence where judges reflect on the fact that it is unfortunate that it took 4 years to get the trial, and given the age of the children and given how long the dynamic has been going on, people are starting to worry about whether a custody reversal is appropriate for those reasons, as opposed to do they work and are they robust remedies. So essentially the point is, you try a compliance motion, you should not have to go back to court time and time and time again for multiple compliance motions, and then at some point escalate that to a contempt motion, and the difference between the two is for another day. They're essentially the same. that's a waste of court resources, and at some point, courts rightly say, I'm not going to make a further order to comply with an earlier order. The earlier order speaks for itself. So it's at that point that you should be able to make the pitch that nothing's going to work but for a structural intervention in the family. Now, do you need, this is a rhetorical question, do you need a mental health practitioner who is recognized to have expertise by the court to assist the court in dealing with that request of the court? Historically, you might think, yes, that's the case. Thankfully, as a result of some cases that I've been successful with in Canada, it's not the case, or not necessarily the case, or you can make a very good argument that it shouldn't be required. The reason for that is there is no one universally recognized diagnostic for what is the principal causative factor of a post-separation dysfunctional family system. There are many models. So, for example, there is a model originally proposed by the late Dr. Gardner, who was a child psychiatrist and who simply observed patterns in the very intractable cases that found their way to him. And he kind of asked himself, what am I looking at here? What am I dealing with here? And took to a study of those most intractable families and found patterns. And that's what he originally published as his proposal to assist other practitioners helping these families. And that's where you have the 8 manifestations in the children. And that model has been revalidated in later years by Dr. Baker, co-authored my book, and in conjunction with the late Dr. Doug Darnell, and many others, and has evolved over time to pick up lists of problematic behaviors on the part of the favored parent. And there's no end to those lists, but Amy has theorized a list of about 17 to 20 of the most commonly reoccurring and quite meaningful negative behaviors. I would add, and I've had this discussion with Amy over the years, that there should also be a focus, at least as much, on what the favored parent hasn't been doing that would have been helpful, and on why the family system isn't healing. Because what you have is the favored parent and children anchoring on what they want to assert is justification for a complete and utter rejection. And they won't budge. They won't let go of those narratives because those narratives give them power. And dysfunctional family systems have messed up power dynamics. And Jen Harnett has written extensively on that aspect. So the standard structural orders that I've come up with for a directive psychoeducational intervention, again, the subject of my last talk for ISNAF, and I'm going to put those up on the screen shortly, are meant to deal with that, are meant to force the favored parent and children to abandon those historical narratives. There's no use debating the past and turning what is supposed to be a healing process into just yet another forum to debate who's right. Rather, we're focused on future behaviors, a new family constitution, if you will, that will be informed by the disputes of the past without blaming, so to speak. So let's just take a simple example. Let's say that what is a reasonable bedtime has been a huge dispute and completely uncoordinated bedtimes between the two homes. And it sounds minor, but you'd be surprised how often something like this becomes the rallying cry. And in recent years, playing Fortnite. One home has structure, and the Wi-Fi goes off at 9:30 at night, and there's therefore no more Fortnite. Whereas in the other house, anything goes. You want to play till 2 a.m., go right ahead. And that becomes a reason why the children are expressing a desire to be at one house rather than the other house. So these are all things that can be dealt with in a family constitution where everybody moves toward the middle a little bit and there's common agreement as to how things are going to go going forward, or that the children are taught that it is normal, that there are two homes that could have different rules and they're both normative. And it's the kid's job just to get used to that. Perfectly normal. So, coming back to the pitch and the elements of the pitch. Try compliance motion, or maybe two. There's been failed therapy. So then you've tried a more structured model of failed therapy, such as I've published. That's failed also. At that point, you're done. And this family will never heal, never self-heal. There will not be a healthy ending without a structural intervention. So now you're into, and a lot of our Canadian cases, which are quite lengthy and quite transparent as to the judge's thinking, end with just a consideration. What are the options available to the court? And, depending on how the judge is writing that day and what other decisions they point to, you usually wind up with four. One is do nothing and maybe refer the family back for more unstructured therapy, which is destined to fail yet again, and somehow hope that there'll be a different result. Not a very logical or evidence-based strategy. Option two, you could increase the targeted parent's parenting time to 50% to try and send a message to the children that this is someone who the court feels can and should be making as meaningful a contribution to your upbringing as the favored parent. And we're sending a message, and we expect this to be followed. And judges, having heard one of these trials, would then look at that option and say, sounds like it might be a good idea on the surface, but the favored parent has not complied with any of the court orders in this case to date, and why should I assume that they will suddenly comply with a court order that gives the targeted parent even more time? So that's not an option. Then there's, well, maybe we should all just give up. And the children will exit childhood having lost contact with a parent who the assumption of all of this, of course, is that it's a normative parent. Parents, they have strengths, they have weaknesses, but there is a very broad range of parenting knowledge and styles that will nonetheless produce healthy young adults. And it is a tremendous loss to children when, despite all the efforts of the adults involved with the family that's in crisis, no solution is found and they lose contact with a parent. The job of the targeted parent and their counsel is to make it clear to the court that the social science literature is overwhelming, which it is, about the damage that children will suffer from the loss of a parent during childhood. Many have written about it, and there's even to the point where meta-analyses are now being done about that, which is studies of studies, where the collective work of the worldwide mental health community on this sort of topic is pulled together. The last and fourth and final option is to do on an interim basis, because this is always an interim order. We're not trying to have the kids lose contact with the favorite parent. It's just a detour temporarily so that the children can regain a resilient relationship with the targeted parent, where the favored parent can be taught how to be a more supportive parent, and what they were doing wrong. It's usually a projection of their own personal views of the targeted parent, who may have been a terrible spouse, but that doesn't mean that they're a terrible parent or that they can't continue to make a substantial contribution to the children's upbringing. After all, the children are genetically half of both parents, and if they continue to think of one parent as all good and the other parent as all bad, they will be at war with themselves. And we increasingly see in cases, and there is increasing peer-reviewed journal literature on the issue of the intergenerational transmission of these maladaptive processes. So I had a case where I got custody reversal after a trial. It went to the Ontario Court of Appeal. It was upheld. And this doesn't appear, unfortunately, in the trial decision, but the favored parent had been completely poisoned and cut off from her own father and was living with the maternal grandmother. And quite clearly had adopted the view that children can grow up healthy and happy with just one parent, and in particular, there's no need for a father. And that came through loud and clear in the cross-examination at trial. So if you can reinforce to the court through testimony of somebody who can speak to that robust body of science, the inevitable and severe damage to children who lose a parent during childhood, because there's ways to admit social science literature in a case and other ways that are not effective under the rules of evidence. Then you put the judge in the following position, which is then resolved by some case law that I'll refer to in a minute. So having heard a case structured along the lines that I've just set out, the trial judge then has to balance the supposed short-term upset in the children who would be told that going forward there's going to be a timeout for the favored parent and they're going to be living with the targeted parent, and there's a whole process in place to heal this up afterward, provided that the children do their part. And you'll hear all kinds of scaremongering on this point, which is not evidence-based. So there's a deniers community out there who don't like this last remedy. Not certain whether any of them are listening in on this presentation, but happy to debate you openly at any time about this. And the deniers community will suggest that this is going to be traumatic for the kids, and they're going to run away, and they're going to potentially kill themselves, and the cure is worse than the disease, so to speak. Now, they'll put this forward without an evidentiary base. In fact, experience has shown that this is not what happens, and that if it is properly explained and sold to the children, this is a liberating process rather than a traumatic process. Because the trauma, the proven trauma, is the trauma of the children being forced to live a lie. The lie that the targeted parent is so bad, so useless, so dangerous to them, that the loss they suffer from losing half of themselves is worth it. And that's trauma. It creates cognitive dissonance in the minds of the child. How can this be? How can this be? And they fight their own memories of better times with that parent. And there's a process of psychological splitting that Bill Eddy has frequently written about and spoken about. And in the case I just finished, the judge remarked on how difficult it must have been for the children to be acting so abhorrently toward the targeted parent that they used to have a good relationship with. And that's where a lot of the cases fall apart for alienating parents. Where's the smoking gun? As the case I just finished accepted, and in accordance with some research that Amy Baker has done, and was also the subject matter of her book, Bonded to the Abuser, those who work in child protection know and have seen that truly abused children still don't, double negative here, they don't not want to ever see the parent again. It is only artificially estranged children or children who, there's demonstrable sexual and physical abuse proven beyond a reasonable doubt might act this way. But you'd see that smoking gun and it would be verified everywhere, and you'd know what you're dealing with. It wouldn't be the typical set of unproven allegations, just throw as much mud as possible that we see from favorite parents. So, coming back to the pitch to the judge, you're asking the judge to recognize that whatever is being put forward as, well, maybe that's too extreme a remedy, is not evidence-based, is not supported by the facts of the case itself, is simply scaremongering, and that in fact, experience and the scientific evidence and the legal jurisprudence has shown that this sort of remedy is not traumatic, does work, and does save families. And as I've said, you don't want to do the same thing over and over, more unstructured therapy, which is inevitably going to fail, and expect a different result. So what does the judge have to worry more about? The short-term risk of upset, often speculative and unproven, or the proven, evidence-based, inevitable, major psychological damage that children face when they lose a parent in childhood. And that is ultimately what you sell to the judge. That if you do nothing, if you say, well, I'll just increase things to 50-50, or if you just send them back for more unstructured therapy, you're going to perpetuate the abuse that is in fact going on. Coercive control is now a concept in much of the legislation. And parental alienation dynamics are both child abuse and domestic violence. When you read the updated legislation, you see it right there. It is a way to get revenge against the other parent where it's going to hurt most, through the children. And it is using the children as tools in that process, or what some who have testified describe as weaponizing the children against the targeted parent. So if you put a thorough case together and it has the elements that I've indicated, you should be successful if you have experienced counsel able to articulate things in this way, and who has knowledge of the tools to bring forward and how to run a cross-examination of the favored parent, of the supporters of the favored parent, and of any experts that the favored parent wants to bring forward. These are difficult cases, and you continually learn from each one. You need very experienced counsel on these cases, one way or another, either as a consult, as I frequently do in the United States, or you find somebody who's successfully got custody reversals in your state to take the lead. So in a nutshell, and of course, the secret is in the execution of all of this, those are the elements necessary to get this sort of remedy in a case. And so one other tool that I'll mention, there is jurisprudence on this issue of short-term focus versus long-term focus. And thankfully, in Canada, where we have a well-thought-out decision, there's no hesitancy with the courts of other provinces adopting and relying on that decision. It's not binding on them because of our constitutional structure, in the same way that a decision of one state wouldn't be binding on another state in the United States. But a well-thought-out decision, since we're talking about the human element, and all family law legislation, even across North America, at its core, is very, very similar on these sorts of issues. We should be able to learn from each jurisdiction. So the case that I'm referring to in particular is a 2007 decision of the British Columbia Court of Appeal, where the trial judge found that it was absolutely a case of alienation, but was worried about the short-term impact on the children and didn't impose a protective separation and its associated intervention, and then reintroducing the favored parent. The Court of Appeal reversed, stating it was an error in law, meaning appellate courts do not have to give any deference to the trier of fact, the trial judge, or motions judge, if it was a motion. And that decision has been cited repeatedly across Canada. I use it all the time in my cases, and it is featured prominently in the successful decisions I've had with this sort of remedy. It was not until 2020, some 13 years later, that we saw a similar, almost identical decision in the Court of Appeals for England and Wales. And that's one of the benefits of having a legal system where courts openly cite each other's jurisprudence. So now what I want to do is, with that background in mind, I'm just going to show you certain of the documents and materials that I assembled for the judge, who was my honor that he reached out to me for what he thought might be an article or two that I've written, and instead he got 208 megabytes of materials in an upload, thus giving meaning again to the piece of rhetoric that reads, be careful what you ask for. So what everybody should be seeing on their Zoom screen now is an article that I wrote last summer. As I mentioned, I'm the legal editor of the bi-monthly, whatever you want to call it, publication periodical of the PASG. And I had noticed in the spring of 1991 that a well-known judge in Montreal, Quebec, where I'm from, had passed. And I knew that Justice Gomery had been the author of one of the first well-known parental alienation cases in Canada. And that decision was so well written, and it's actually quite succinct, certainly compared to the 64-page decision that I was recently successful on. And even then, if you had really tried to incorporate all of the very interesting evidence, it would have been a decision into the hundreds of pages. But here we have a case from 30 years ago that absolutely nailed, and I'm going to take you to some of the quotes from the case. It absolutely nailed some of the concepts that I've shared with you this evening that took decades of research and conferences for these concepts to be as well understood as they seem to be to the practitioners and Justice Gomery 30 years ago. So as I state in this, as you can see this rather large paragraph down here at the bottom of page 1, that there were some nascent cases in Canada in the mid to late 80s that were dealing with these intractable family systems. They weren't necessarily referring to the term parental alienation, but certainly dealing and struggling with the concepts and making very strong statements that a parent who is undermining another parent's relationship with the children is committing child abuse. Something that for some reason the deniers community doesn't want to accept, even though it's classic child abuse. For those of you who have been studying this area as long as I have, in the early 1990s, prior to this 2007 BC Court of Appeal case that I was referring to, there was a long-running case of Hart versus Hart, where the system did not respond appropriately, and the child caught in the middle ultimately committed suicide. And this is the saga of my good friend Pamela Richardson, who wrote the book A Kidnapped Mind and established a foundation for study in this area. And I'm privileged to call Pam a friend. And this is what can happen if courts don't intervene appropriately. So it's in that rather undeveloped environment that we have Justice Gomery in 1991 in Montreal. And I want to point out some of the quotes to show you that this case was, say, 30 years ahead of its time and should still be studied. So first thing I'm going to do is I'll highlight here so it pops out for everybody. So I had mentioned that Amy did some validation work within the last decade, that children who completely and utterly reject a parent, unless you can point to, there it is, that parent was criminally convicted, there's the massive ongoing physical abuse and sexual abuse, and that's why the child is reticent to have anything to do with the parent. But for that, abused children, psychologically abused, physically abused, don't completely reject a parent. So here we have a statement from the social worker involved in the case at that time, more than 30 years ago. The complete and total rejection of a parent is almost never seen, even in cases where that rejected parent has abandoned or abused a child. So decades later, we're starting to come around to the view that the intractable, it doesn't matter, no matter what, I never want to speak to that parent again, is so artificial. It doesn't mean that this is, there it is, that's all you need to know, which is the false dichotomy of the denier community, who accuse the PA science community of just saying that's all we need is a rejecting child and it has to be PA. Absolutely incorrect. All of the diagnostic models, and there are many, there is no one overall diagnostic model. You really just look at these cases as, what is the favorite parent doing that's distinctly unhelpful? What is the favorite parent not doing that would have been helpful? And where are the court orders that the favorite parent has been breaching all the time? And where is that one properly structured psychoeducational intervention that the favorite parent sabotaged? That's basically it. But this is an input into the overall analysis of what went wrong in this particular family. It is one input. So if you hear from the denier community that, they look at every rejecting child as absolute concrete evidence that it's PA, absolutely 100% incorrect. But yet, a child who totally and utterly rejects a parent for the types of reasons that we see in these cases, let's say it raises a suspicion, it raises a clinical hypothesis that this may very well be artificially induced, and then send you off looking for corroborative evidence. So that's a good way to look at this factor. And here it is in a case in 1991. Okay, the next thing that I want to show you where Justice Gomery was far ahead of his time. All four children have chosen to renounce and suppress their natural feelings for the mother they love or loved until the marriage broke down, and to identify themselves totally with the hatred for her which animates their father. The court cannot remain indifferent to the danger to their future emotional stability this behavior represents. So there we have something that it took decades of work to have this overwhelming body of peer review literature that I will show you in a minute. It is irrefutable that this is not the speculative damage. This is the inevitable damage, and it's major damage that children who lose a parent in childhood are going to suffer. And yet, in 1991, here's Justice Gomery stating it with conviction in his decision. Okay, absolutely brilliant. Here's the next thing I'm going to show you. The court has the impression that Dr. Lefebvre allows herself to be used by the defendant. A psychological assessment which does not attempt to include the point of view of one of the parents is of limited value, and no explanation is attempted as to why the children were so openly hostile to their mother, for whom they had had great affection until only a short time before. So this highlights the dangers of the individual therapist for the alienating children, who only gets half a story. And that process, and you see a lot of favored parents shop the children around until they can find a therapist who is happy to just engage, even though they have no interaction with the other parent. That's usually a no-no, and perhaps professionally risky. And here we have in 1991 recognition of that. Now, the catch-22 or double bind that the alienated or targeted parent faces was beautifully captured by Justice Gomery here. The rejected parent is in a situation where he or she cannot do anything which is not perceived by the child as being bad or wicked. Even the most innocent remark or gesture is used by the child as evidence justifying the child's alienation. So the targeted parent is under the microscope. The targeted parent can do no right. The favored parent can do no wrong. And that's just not how human beings are. So when you see that black and white thinking or splitting, think Bill Eddy and think yet another piece of the diagnostic has been proven out. Now, lack of empathy. There are 4 or 5 major tasks, developmental tasks of childhood. Emotional regulation, avoiding antisocial behavior, learning empathy, learning responsibility. These are things that if you don't learn those core principles in childhood, it's very, very difficult to learn it later on. And here's what Justice Gomery wrote about failing to learn empathy as a child. The children have seen their mother weeping on many occasions, and they unanimously conclude that she is faking, and that is a demonstration of her lack of sincerity. They do not seem to be able to comprehend that their contemptuous, rejection of her causes her genuine grief. Clear lack of empathy. And that's both a diagnostic tool and a predictor of future mental health problems. Now, the failure of conventional therapeutic interventions, which I spoke of last time, here you are, 1991. Mrs. Greenberg, a well-known Montreal-based therapist, by the way, testified about the failure of her attempts at therapy, a failure which she attributes to the systematic obstruction of her efforts by the defendant. Well and succinctly said, you just don't keep doing the same thing over and over again and hoping for a different result. So there were comments on the children's views and preferences not being reliable. There's comments here that the targeted parent does not have to be perfect. No parent is perfect, but the typical errors that targeted parents make don't cause the complete rejection that we see in these cases. Here's a great piece of rhetoric speaking about the alienating parent down here. And it justifies the protective separation. Defendant, the father, has deliberately poisoned the minds of his children against the mother that they formerly loved and needed. In the court's opinion, a father who would act in this way represents a grave and persistent danger to the mental and emotional health of his children. Once again, worry about the long-term impact. It is an error in law to focus on the short-term impact. Here's a great piece of rhetoric. Hatred is not an emotion that comes naturally to a child. It has to be taught. Think about that. Children are born to love. They're genetically built to take in caregivers, not to push away someone who only wants to love and support them. When you see that, it's another key diagnostic. And look at this piece of judicial rhetoric. If you see a child expressing hatred, it has to have been taught to the child because it's simply not natural. And so the protective separation is then justified. The person who has taught the children to hate is their father. They would be better off if he were to be removed totally as an influence upon their development until they are able to withstand and reject his negative attitudes. So I could run a course, I guess I'm running a course this evening, teaching people about PA using two tools. This decision of Justice Gomery in 1991 and the movie Erasing Family, which I'm a proud sponsor of and know the producer quite well. To see it play out in that form in the movie, which is just brilliantly done, and it's now available for free on YouTube or for a small fee on Vimeo. That, in conjunction with this decision, pretty well tells you what you need to know. Okay, so I'm now going to, in the limited time I have left, pick another spot or two of things that I think would be helpful. But I do want to mention two somewhat related processes in these sorts of fractured families. So I'll just stop sharing for now. The concept of enmeshment and the concept of gatekeeping, because they will both result in a situation that looks confusingly similar to a PA case in terms of the children not being able to transition from home to home in a healthy fashion. And I will, for everyone's benefit, answer one question that's in the chat. People want to know, what is the citation? The case is difficult to find in because of when it took place. There was a short appeal, but really just on the basis of judicial bias, which upheld the decision, and that is publicly reported in 1992. But if anybody is interested in the decision itself, just email it to me and email me a request, and I'll be happy to send you the decision. So in the case of enmeshment, the child is so bonded to the favored parent that the child has difficulty separating, and you usually see co-sleeping and the child managing the emotional state of the favored parent instead of the parent being of assistance to the child. Now, even though it is some 17 years old, the best article I've ever seen, it was part of a conference that took place in 2005, and they published all the papers, Haworth Press, in a book. But for your purposes, what I'll do is I'll share screen and show you the article so people can write down the citation. Just give me one sec. There it is. Okay, so here's the article. Revisiting the Construct of Boundary Dissolution by Patricia Carrick. This article tells you everything you could possibly want to know about enmeshment, and you can see it was part of a book, Implications of Parent-Child Boundary Dissolution. The article itself was co-published simultaneously in the Journal of Emotional Abuse. So here it is, and you can buy the individual article by going to haworthpress.com. They may have been purchased by somebody else in the interim, but I assume that link will still get you there. Absolutely well worth reading. There's a chart that I'll show you briefly here. Terms used in the conceptualization and study of boundary dissolution. So there's enmeshment, just as one example, and they put who the leading theorists were. There's Salvador Minuchin, one of the deans of the family systems thinking of the 1970s. But some of you would be familiar with triangulation, psychological control or coercive control, a parentified child, the concept of parentification itself, intrusive parenting. So I have a book written by Barber called Intrusive Parenting, very hard to find it now, that these are all different aspects of a parent failing to respect the hierarchies and boundaries that are the definition of a healthy family system. So that's enmeshment. I'll stop sharing that. Then there's another concept of gatekeeping. And this is just one parent who finds it threatening to share the child, to have the child go back and forth between the two homes. So they want to be the one making all the rules all the time. And you're forever negotiating and begging and pleading with them for parenting time. When the child does come, the child probably has a good time. There's no hatred. There's no anxiety. You just can't get them there. So that's not parental alienation. That's gatekeeping. Does it produce very bad results for child development? Of course it does. Is it in accordance with the maximum contact principle that you see in much legislation? Of course it does. Does it offend the friendly parent principle that you see in much legislation? Of course it does. But it's not parental alienation. It just looks like it. So very, very important to understand some of these parallel processes. Okay, some of you may worry that, well, I've been told by my lawyer, courts don't like the term parental alienation. We shouldn't even raise it because then we get into this whole controversy. Once again, nothing could be farther from the truth. You don't shy away from the conceptual approach to advancing a case that is necessary to explain to the court that leaving the child with the targeted parent when all else has failed is going to produce extremely damaged children. Justice Gomery saw it in 1991. So, what of the criticism of the concept? It is not tied to any one person. Nobody owns this maladaptive process of child adjustment. Nobody says it's my way or the highway. And so if you can attack their model, down goes the concept. So all the efforts of the denier community to unjustifiably throw mud at Dr. Gardner, and there are well-reasoned articles that refute all of the mudslinging, is simply they're trying too hard because they're too scared, because there's too much case law that simply adopts it. I was involved in a case in Ontario back in 2021. I was assisting another lawyer where the judge came right out and said, it doesn't have to be proven. We judges all know what it is, that it's immensely damaging. I'm taking judicial notice of what it is, as many judges before me have done. Think about the power of that. The war's done. The war's over. The denier community just doesn't realize it yet. And they will keep fighting and publishing and losing time and time and time again. Every time the denier community has hired some large firm to do some pro bono amicus curiae brief in a case that PA doesn't exist and it's just meant to cover up for abuse, they have failed. And they will continue to fail because they're not speaking truth. Nobody owns this concept. This is a concept with a very long history, long before any of us. It just describes the human condition. So let me show you proof of that. I'm going to share my screen again. Okay. I scraped this from Flickr a very long time ago. Somebody went to the trouble, obviously, of going to libraries with, rare book libraries to assemble newspaper clippings and magazine covers using the phrase parental alienation going back 200 years. And I'll give you an example. Here's a case in the United Kingdom, the Westmeath case, from 1820. There it is, parental alienation. Dr. Gardner wasn't even a thought in his great-grandparents' mind. So he doesn't own this. This is a colloquial description of a set of maladaptive behaviors on the part of children that have their root in a combination of parental behaviors and a lack of resilience on the part of the children to those behaviors. That's it. And if you look at the left-hand side, which are all the bookmarks, I could take you all the way through from 1820 right through, and here's something where it starts to get into the science. So in 1949, there was a psychoanalyst, William Reich, who, without using the particular phrase, spoke to the concept. Revenge on the partner through robbing him of the pleasure of the child. And again, it's not gender-based, it's a power dynamic. I showed you that Justice Gomery's decision, the offending parent was the father. And in all of the prevalence literature that Jen Harmon and others have done, it's roughly balanced. Okay, this is a power dynamic, not a gender dynamic. There goes the argument of the denier community that this is somehow a construct of abusive men. It is absolutely not. It's a maladaptive exercise of power. So if you then want to, and I'll stop sharing this one, see a peer-reviewed treatise on this, many of you will be familiar with the AFCC, which is one of the largest organizations of practitioners, legal and mental health, trying to assist families after separation. And they have a publication that comes out, I think, 4 times a year called the Family Court Review. In 2000, and then again in 2010, and then again in 2020, they devoted the entire issue to articles about parental alienation. The Parental Alienation Study Group, through its chairman and founder, Dr. Bill Bernay, who is known to many people involved with ISNAF, a professor emeritus at Vanderbilt. He and others working with him have assembled a 1,300 document library at Vanderbilt on parental alienation, book chapters, peer-reviewed journal articles, etc., in multiple languages from around the world. This is a very mature science. But if you want to see a written description of what I showed you, that it also has a long pedigree, you would go to the April 2020 edition of the Family Court Review and look for Demos's article here, showing that, and he was only looking at US appellate courts. It's all over the place. It is just absolutely accepted science in the courts. And here he goes through the history of PA. And so he jumps to David Levy and the Children's Rights Council, William Reich, and what we saw in 1949, and then another practitioner in New York in 1953, and then the family systems theorists of the 60s and 70s, all of whom, using different terms, here's that cross-generational coalition again that we saw in the enmeshment article, long before anything from Dr. Gardner. And then here we have Wallerston and Kelly in 1976. And then in 1978, a child psychiatrist introduces the concept of brainwashing, which is what happens with these kids. And the introduction of falsities, misrepresentations, and cognitive distortions in the mind of these children is a key diagnostic in the 1,000 family study published, it's now in its second edition by the American Bar Association, called Children Held Hostage. That is Clewar and Rivlin's book. So you can see how the concept of parental alienation, it's just a term that describes a concept because it's just too unwieldy to talk about the concept all the time. And in the very limited time that I have left tonight, I told you that it's almost impossible to do justice to this in an hour and a half. I'm going to show you what I feel is the best definition of PA that I've ever seen, although all of these here in Demos's article have scientific merit. They've become part of mainstream mental health understanding. Has nothing to do with Dr. Gardner's attempt to come up with a diagnostic for it. And generally we want diagnostics so we know what it is that we're treating. So it's very important to know this stuff, to know where you can find this stuff so that in case you get a denier presentation in your case, it can be easily refuted. Okay, so I have very little time left, so I'm going to pick my spots and jump to some other things. So the judge who was inquiring for some assistance with his presentation, I did share him several of my previous presentations on various topics. I shared with him, you're going to have a real treat next month when Dr. Steve Miller will be presenting, and I shared some of Steve's materials. When I last spoke for ISNAF and I took you through a structured intervention model, I showed you the requisite orders requested and the objective measures of success. What should we be shooting for? What does healthy child behavior look like? And if anybody's interested in that, I'm happy to resend the PowerPoint and some of the other associated material. And maybe Cindy and I could look to posting some of this stuff on a page that I think ISNAF has for me. I had assembled a folder of the leading social science literature, and it goes on forever. I've alluded to the Vanderbilt 1,300 pages, but this spans some diagnostics, some of the leading articles about the damage that is inevitable with these kids, and also a bunch of therapeutic intervention articles, why we need protective separation, studies of the Family Bridges program, and Jen Harmon's recent study of the Turning Point for Family program, and that is the program that the children in the case that I just finished have gone to and just come back from, and we are making progress there. So it's important to also understand all of that social science literature. It's important to understand the jurisprudence on failed therapy and why therapy fails all the time. But again, that was the subject matter of my last presentation. So there's a lot of law and thankfully, I think Canada is as far ahead on this as any country in the world. There's very robust law on these protective separations in Canada. And the most interesting part is on the back end, when the favored parent wants back in to the children's lives and says, I've done my work, I've worked with these specialist therapists, I do get it now, I see what I was doing, and it won't happen again. And I'm making the same argument. I can go back to making a substantial contribution to the children's lives. And assuming all of this is certified by the therapist who's running the whole after trial program, that's the goal. You're not supposed to fight this. You're supposed to welcome this in the same way that since all other remedies have failed, you're supposed to welcome the fact that we're now going to try a structural intervention in the family, because frankly, there's nothing left. So if you are good intention, you say, yeah, I guess we try that for 3 months. What the jurisprudence has shown us, when there is disputes, the favored parent may not have done the work, may not have not yet safe to be reintroduced, or not yet safe to just jump back to 50-50, have to do it a bit more gradual and monitor for regression. And then you get a decision where the court hears evidence about the progress the children have made to date in reconnecting with the favored parent, and the progress that in reconnecting with the targeted parent, and the progress that the favored parent had done in taking ownership for what had happened so far, committing to change, and demonstrating the ability to change. And then the court, based on all of that, will say, okay, here's what we're going to try, and then you'll come back and see me again in another 3 months with an updated report. It's time to reintroduce the favored parent, not as fast as they want, but I'm gratified to see that the children have reestablished relationships, etc., etc. So the increasing body of protective separations leads to an increasing body of jurisprudence about what things look like on the back end of the protective separation. And it's looking very good indeed. It ties in with the studies that Dr. Warshak has done of family bridges, and Professor Harmon has done of turning points, and that Karen Woodall is working on one in Europe based on her interventions, and Professor Harmon will shortly be moving to finalizing a third study on family bridges that she's done. So it's all tying together. We know that protective separations work. They have all the tools to work. And so I'm going to share screen here. So this is part of my submissions on the trial that was just completed. And so you can see here the submission: protective separations work where all other interventions have failed. So why is that? And the answer, and here's one of the decisions, by the way, on the back end. So Justice Hebner in 2016, following on a case that I won in 2013, says the following: on the evidence as a whole, I find that the change in custody has made a remarkable difference in the relationship these girls have with their father. In fact, I can safely say that the change in custody has saved the relationship. Were it not for the change in custody, I have no doubt whatsoever that the children would not have any sort of relationship with their father. And we have lots of decisions like that about recognizing that the structural intervention in the family was the cause, not even the specialist program, because in the Wiggins case here, they didn't go to a specialist program. They just continued to use their local therapist in Windsor, Ontario, who was actually not in favor of the protective separation. The court rejected his input, and that's the same person that they continued with. So it's not the specialist program. They can certainly help. It's the protective separation itself. And here's another one, X versus Y. Somewhere in here, I explain why, and I just want to show you the paragraph. Okay, well, I can't find it quickly, and we are running out of time, so I'm going to explain the rationale. This is a very thorough statement of law, and as you can see. Okay, so why? Why do they work? They work for a very simple reason, and it works every time for this reason, provided that there isn't surreptitious contact. You're changing the incentive structure of the family. Prior to the protective separation, the children are well aware that the nicer they act toward the targeted parent, the more time they're going to have with them, and the less time they're going to have with the favorite parent. And they act accordingly. It's not in the interest of the favored parent or the children to treat the targeted parent with love and respect. After the protective separation, that incentive structure is flipped on its head 180 degrees. Now the rules of the game are, if you'd like the favorite parent back in your lives, then just learn to treat the targeted parent with respect and love, the same respect and love you used to treat the targeted parent with, the same respect and love that you treat the favorite parent with. So not only is that a very simple task for the children, you've empowered them. They're in control of their own destiny. A protective separation sold to the children, explained to the children in these terms. Hey guys, I'm giving you the passcode to your dilemma. Treat the favored parent, treat both parents with love and respect, and you get both parents in your life. But continue to act like you did, and you won't have the favored parent in your life. So make an intelligent decision. When this is explained to the children that way, and that whining or protesting or refusing to participate in the program will only result in extending the no contact period, they figure it out real fast and their behavior comes around accordingly. And this happens every time. Just because it's like the law of gravity, it's going to have a noted, expected effect. So in answer to the scaremongers and the deniers community, protective separations are an inherently interim remedy. They are meant to give the children two parents in their lives. Doing nothing or continuing to overempower the favored parent and the children will guarantee that the children only have one parent in their lives. it's an irrefutable argument. And that, in a nutshell, is the hour and a half elevator meeting, 80,000 foot treatment of how you can be successful in getting this sort of remedy. And I've gone slightly over. I'm sorry for that. But there you have it.
So thank you, Brian. And thank you all for joining us. And a special thank you to Brian. He has been always, for years, prior to my participation with ISNAF, was already doing this work. I actually saw him speak at my first conference that I ever went to as a targeted parent. And Brian has continued to do the work. He's really collaborated with ISNAF since its inception in 2008. He's on our advisory board and works very closely with our board. We're always grateful when he's willing to present, and he always is ready and willing. And also he advises ISNAF on any of the legal challenges that as an organization we might have. So I want to say thank you again for all the contribution that you give us free of charge. And you are just a powerhouse in your knowledge. I want to invite everybody to please go to Brian Ludmer's website. He has multiple things posted on there. Do visit there and take some time to take a look around. He has so many things and he keeps posting more and more. Unfortunately, we don't have a page to post, but if you go to Brian's page, he has everything you would need and then some. So you could probably just do a whole lot of research on that. So with that, I want to say thank you again to Brian, and we will have you back again. We are looking at putting together a panel of all the distinguished people on our advisory board later this year, and we will be in communication on that. So anybody who needs to reach out to Brian, Brian, do you want to give your email address
Sure.
Method of contact?
Sure. So it would be, it's actually posted here in the Zoom screen. If everybody can see where my picture is. Brian,
okay, yes, we can. There we go. Brian at ludmerlaw.com. So if you need to reach out to Brian, there's his phone number. I invite you to visit his website before you call to inquire any questions. You're going to find a lot on his website. He has had that amazing information on there for years and years, and we tell parents to go there all the time. So once again, thank you, Brian. And with that, I want to thank you all for taking your Sunday night to participate. Our next meeting will be on May 15th. It will be an interactive meeting, and our president, George Ross, will be the one leading that meeting. And we're looking to tentatively have Dr. Stephen Miller present in the month of May. Tomorrow is Parental Alienation Awareness Day. Please make sure that you do something to forward that conversation. And do send us your judges. You'll get an email first thing tomorrow to do so. And look around on the internet. There's all kinds of people doing all kinds of postings and bubbles and all kinds of things in the world of parental alienation. The Parental Alienation Awareness Day, I believe it was founded in about 2010. And it, at that time, started in San Diego, and it was just a small little group of people that got together at a park with bubbles. And it has expanded, and we're intending to expand it, continue to expand it further. But if everybody takes their time to just take a moment to inform one person, imagine how much forward we will be sending that knowledge and information. So with that, I'm going to read our closing affirmation. And that is, fear isn't your enemy. It's a compass pointing you to the areas where you need to grow. So I know when we're all in court, there's so much fear. So just stay in the work. You're not the ones who, are lacking doing your research. You're sitting on this call on a Sunday evening when you can be doing all kinds of other things, and you're doing your homework. So just stay focused, keep doing the work. We heard from Brian today. The history's there, the case law is getting there, more profound. Just keep digging and, do your work to make sure you do have the knowledgeable professionals on your case. And if your attorney isn't knowledgeable, Brian Ludmer is strategist, and he can work with counsel and help them become knowledgeable and understand how to present your case. So with that, once again, thank you, Brian, and thank you all for joining us this evening.